I'm Sonali Naik. I'm Joint Head of Dukes at Garden Court. I'm leading my colleagues Adrian, Berry, soon to be KC, Jen, Twite, and Audrey at Mogan. What we're going to be covering today is, it's criminal. Yes, yet another borders bill. I mean, we need another one. So on the 30th of January 2025, the government introduced another immigration bill, the Border Security, Asylum and Immigration Bill 2025. And obviously there is some good news in that, which is that there's the repeal of the Safety for Rwanda Act and parts of the Illegal Migration Act. But there's also, we'll today, some new criminal offences, provisions relating to modern slavery. And so I'm just going to do the introduction to where we are, then I'll hand over to my colleague, first of all, Adrian. But just to set the scene, which is what are the stated aims of this legislation? What do the governments say they're doing? So they say that they're strengthening the UK's response to border security. They're going to set out a framework in which the Border Security Command will work. They create new powers to strengthen the ability to identify, disrupt and prevent serious organised crime, and strengthen and support the asylum and immigration system. As well as repeal some provisions in the IMA and repeal the Safety for Rwanda Act. Obviously that had to go because of the sort of totemic, really, in light of the history of the litigation and the way in which the legislation was commenced and the questionability, significant questionability of whether it was compatible with the rule of law. So that's what the government said they're doing. Why are they doing it? So again, this government, unlike as well as the previous ones, have referred and contextualised this against the number of small boat entries. So small boat crossings have been the predominant method of entry for irregular arrivals since 2020. And this method of arrival has increased very significantly. So I think in 2018, there were like 300 or so. And now entry by other methods which had declined post-Brexit, post-Dublin Convention, and increased securitization with the French border controls. So that's why this is happening. And you can see there the numbers in 2024, 36,816 migrants crossed in 695 small boats, which is another increase from previous year. And also the number of people carried on each boat, which is something else that the government have referred to in their introduction and explanation as to why this legislation has been introduced. So by the end of 2024, September 24, less than 1/5 of detected irregular arrivals were otherwise, came to the UK by inadequately documented air arrivals or people who were in the UK and detected either at port or in country. Obviously, we know that alongside asylum schemes, we've got humanitarian visa schemes. And we've had which are some way described as generous humanitarian schemes in relation to refugee and humanitarian crises. And in the last 10 years, the UK has resettled or brought to the UK about 400,000 people under protection schemes. There is an additional number in relation to Hong Kong, which I didn't include in that number, but about 400,000 within the Syria, Afghan and Ukraine settlement schemes. But there are arguments that, and this is how it is put by some, that if those schemes are generous enough, they could compensate for restricting asylum and access to territorial asylum. But I say that misses the fundamental point of the protections within the Refugee Convention, which were introduced to avoid states applying their own discretion about who and who should not qualify for protection. And so if I make one point today, I would like to just for us all to remember that the important point of the right to territorial asylum within the Refugee Convention. It is the fundamental way in which the convention operates, the fundamental purpose of the protections within the Refugee Convention, which, as I said, were introduced to prevent states applying their discretion about who should and should not qualify. Those programs, humanitarian programs, can't replace this, and if they do, they will just miss the point. The individual right to asylum, which is critical in understanding that principle. And the history of that is that the international community defined who has the right to seek asylum, and it was clear that it must be based on a person's need protection from persecution. I just gave this particular example because I think it's useful time to remind us all that in 1938, there was a gathering of countries who were trying to reach an agreement about who to let in of Jewish refugees fleeing. And at that time, the protection was dependent on individual countries' discretion. So Switzerland said, well, we'll have political refugees, but we're not going to have anyone who's seeking refuge on racial grounds, for example, Jews. I mean, we all know that history, but it's quite stark to see it written down. It's quite stark to see that states did gather, took a decision, and one that had those consequences. So in the wake of the Holocaust, the international community defined who had the right to seek asylum. And that is why I say it's really important for us to remember that principle when we come to look at the provisions in the bill and set against the contextual legal framework that we had prior to that in any event. So what has been retained, this is just a sort of whistle-stop tour before Adrian, Jen and Audrey take you through that. But there are really important parts of the IMA that have, and NABA, which isn't even really mentioned in the bill, which have been retained. And that is going to cause significant problems. So whilst the duty to remove under Section 2 of the Illegal Migration Act has been repealed, that, if it hadn't been repealed, quite frankly, would have been in a completely unworkable situation. That's why it was never brought into effect. Safety of Rwanda Act has been repealed. But critically, there's been no repeal of Section 59 of the IMA, which is the inadmissibility of some asylum and human rights claims, which are from EU states, which may be perhaps unsurprising, but also other states which are deemed safe, one of which includes Albania. But importantly, within Section 59, I think Adrian may start to cover this, is that the government can add states that they deem safe. And that means that there is not necessarily any safeguard against a Rwanda type situation happening again. There's no repeal of Section 12 of NABA, which is quite an interesting position, which was the distinction between Group 1 and Group 2 refugees based on their method of arrival. So if you didn't come lawfully or through a scheme, then you were treated in a discriminatory and a different way in terms of the type of protection you had, the length of protection you had, whether you could bring your family. And there were shades of that already when we see within the citizenship policy that's just been announced for refugees who came irregularly. So even though the previous government started Group 1, Group 2, then abandoned it in 2023, Robert Jenrick said, okay, we're not going to do that anymore. It's still on the statute books. Priority removal notices and abbreviated appeals, although it wasn't commenced in NABA, still on the statute books. Accelerated detained appeals, which was commenced, it remains. Section 29, removal to safe third countries whilst your asylum claim is pending, still on the statute book. Other things, obviously, Adrian's going to talk about these other provisions, including the modern slavery and disqualification, and importantly, the detention powers. In fact, they've actually increased those detention powers in the way that they've been the codification of the Hardy-Singh principles has been retained, and the extension of the powers pending deportation. So it's not, when you see what has been retained and what has been introduced and what's proposed to be introduced, it's actually potentially quite a frightening picture, and not certainly one that's not compatible with international law or the Refugee Convention, in my view, on particularly in certain of the inadmissibility and criminalisation provisions. And what does it mean? I mean, I'm just going to say that in one or two sentences and then Jen will talk about it. What it means is all persons, including and intending to include refugees who arrive crossing the channel irregularly, are guilty of a criminal offence to which they have no defence in law. That was the intention of Parliament, that's what was said. And NABA, which hasn't been amended, redefines how the Article 31 under the Refugee Convention is going to be interpreted and applied. And remembering, of course, that any of those who are found guilty and sentenced to more than 12 months imprisonment are liable to automatic deportation under Section 32 of the 2007 Act. Now, that may not be any of that news to you all to many of you in this room, because those are quite well-known provisions to you. But putting them all together leads to a potentially really dangerous picture in terms of what can be used in the current legislation and how it may be used in going forward. So I'm going to hand over to Adrian, who's going to talk a bit more in a bit more detail about how that's going to be, what the more detail of those provisions are. Thank you very much.
So, thank you. We have a new immigration bill, back to possibly an annual bill. We will find out as the years tick on. But the way to understand this is that it sits on top of recent legislation. There's a tendency to think, because we have a new character, a new political government, that somehow there isn't continuity. And of course, also because the Safety of Rwanda Act is being repealed, that somehow there aren't elements of continuity. But the best way to get our heads around the border security bill is to understand what continuity there is and how it fits together in a developing suite of statutory provisions that govern the processing of asylum claims and immigration control to try and inhibit people coming to the United Kingdom. And so when you actually look at the bill, and you start stripping out the stuff, there's a lot of stuff obviously about criminal offences and connected powers, which we're going to hear about. And then there's a lot of stuff about the border security commander, a person who already exists, but who's going to be given some kind of statutory underpinning, which no doubt will come as a great comfort to him. But actually, when you look at the asylum and immigration stuff, it's interesting for what they repeal and then for what they don't repeal from the previous government. And you don't often think of a Labour government as continuity conservatism, but in some respects, when you look at, well, you shouldn't anyway, but when you look at the continuity of the Nationality and Borders Act, you do see more elements of continuity than change. And so simply because the disgrace that was the Rwanda Act has been repealed isn't necessarily a guide to a massive change of direction. The tide might still be going out in some respects for asylum seekers. And you can see that in terms of what they have retained from the Illegal Migration Act and what they have retained from the Nationality and Borders Act. So the question with this bill is, how does it fit together and what's retained to form a comprehensive set of statutory provisions, albeit that they're distributed across those three acts, the Nationality and Borders Act, the Illegal Migration Act, and the current bill. And so it's important to look at it in that way. The current Home Secretary was chair of the Home Affairs Select Committee while the Nationality and Borders Act of 2022 was in passage. If she's chosen to retain all of it, that's for a reason. There is no way in which this is done in the dark or by oversight or by the Home Office in Marsham Street. These are political choices. And then the elements of the Illegal Migration Act have been kept, they too are political. So in the time available, I just want to give you a rough tour through what we have if this bill becomes law at some pace, because if we're pushed for time, but just to give you the oversight. So when we come to think about it as the bill's in passage, and as practitioners, when we come to apply it, we'll see what we have to do on behalf of our clients. And so you can see there that there is some, that we have these new provisions and that they fit together, as I mentioned. And then you'll see what we have from the 2022 Act. It might seem like a funny place to start, but if they haven't repealed it and they're repealing other provisions, then it's important to understand what could be used. And so you start off with looking at the provision for differential treatment of refugees, depending on whether you came directly to the UK without delay, and that can affect what sort of leave a refugee gets, what kind of the access to permanent residence, the conditions imposed upon the leave, the access to family reunion rights. Not used by the previous government, but not repealed under this government. And if you think when this bill becomes law, then around the time of the party conference season in the autumn, you may see a development in government asylum policy. This bill is now on the statute book. There'll be policies published to surround it. It will be supported. You will find that it could look back quite easily and invoke these provisions and try and use them to create two classes of asylum seekers in the way originally envisaged by the previous administration. The choice to retain is a positive choice. And then in addition to that, they maintain other things from the 2022 Act. So you can't claim in the territorial sea of the UK, you can't make an asylum claim. You have to be on land. In the context of the suite of criminal offences about the crimes of arrival and the powers to interdict vessels in the territorial sea and in international waters crossing the channel, that makes a difference. Provisions in relation to admissibility claims remain in force again, and we'll come on to look at that, but that's important if you're trying to return people to their home state, not just to third country removal cases, as we saw with Rwanda. But the choice to retain those provisions again. Other things to look at, priority removal notices. Some people, quite rightly, they were never really used by the previous government. They come from the 2022 Act. They're not in force, but they haven't been repealed either. And they allow people who bring late asylum claims to have they must appeal if they're refused only in the upper tribunal. They begin there, and it restricts onward rights of appeal. So that kind of punishment, if you like, for not applying immediately could be brought into force, particularly later in the parliament as well, when the government is facing a general election. If you've chosen to retain something, it remains available to you. And so those expedited appeals, priority removal notice invoked, procedure for governments never lose interest in or heart in accelerated detained appeals, no matter how many times the court rule them unlawful. Those provisions remain in force. And then provisions for the removal of appeal rights out of country where a claim is certified as clearly unfounded remains unchanged. All of these things remain available as a result of this bill, and choices have been made to retain them. And again, particularly important, the statutory definitions of the Refugee Convention, which freeze and narrow definitions and apply under the convention, even though senior courts around the world interpret them in certain ways, and our courts have always done. There are statutory definitions of key provisions. There are statutory provisions in relation to age assessments and the way to approach them for those of us that conduct those trials, which remain there, although not the appeals section. And then there are also some provisions. I've divided the modern slavery provisions into those which are in force, not necessarily to anyone's advantage, and those which are not in force. So you can see it's important to understand that there hasn't necessarily been a change of direction about the things which were brought in to narrow the ambit of the effectiveness of modern slavery protection under the previous government. Much of that has simply been retained and indeed amplified under the current bill, as we'll come on to see. So you have to look at what's retained, and then that might be bad enough on one circumstance. And then in addition to that, you would look at, have they augmented it? Have they gone even further? Because this is not a bill about generosity towards protection of fundamental rights. It's still trimming, even if it's repealing the wilder excesses of the previous administration. And so that was the Nationality and Borders Act. You can see the Illegal Migration Act. Much of that has gone. If I don't mention something, it's because it no longer exists if this bill becomes law, and therefore we shouldn't trouble ourselves with it. But the things which we're most concerned are things which are attained in some respects. And Sonali's already touched on the periods for which people may be detained over and above common law constraints controlled by High Court judges. It's the opinion of the Secretary of State can now trump that as a result of legislative fiat. Further disapplication in relation to modern slavery provisions, which we'll come on to look at. The upgrading, which I'm sure they're very grateful for, of first-tier tribunal judges to wear bigger hats in court, to be members of the upper tribunal. And then further admissibility constraints, caps on the number of entrants. If anyone was able to identify a safe and legal route, they might then have to get inside the cap of the number of people who could benefit from it. And then further impairment of the credibility of claimants, depending on how they make their claims. So looking at detention, as we've already touched on, Section 12 remains in force, removing common law protection, liberty, the expertise and institutional competence of the court to govern the right, protect the right to liberty in a common law system. Not good enough for the Secretary of State under the previous government, and not good enough for the Secretary of State under this government. She knows better, literally. It's her opinion which matters under Section 12. And so the idea that the reasonableness of the length of detention tailored to the purpose and effort behind removal would be sufficient, and you could trust that. Insufficient for the purposes of the policy of the government, and say they can continue to detain people when the reason for detention, such as removal, ceases to apply, or removal is not possible within a reasonable period of time. And there's a very good slide, in fact, developed by Sonali on this slide on the screen here, which shows you the 4 Hardiel-Singh principles, the 2 which the Secretary of State gives emphasis to, are now embedded in statute, the ones identified in bold, and the 2 which she's less concerned about, Parliament has effectively displaced because they now don't form part of the statutory test. And so you can see there in the citation for moving away from the common law principles, which are iterated in a number of cases, but particularly in that one among others, as to how to approach detention and periods of detention. Very important if you're running unlawful detention cases, very important if you're concerned with the disjuncture between the statutory ability to detain and Article 5 of the Convention on Human Rights, which of course still applies. You may not get a remedy locally. You may have to go to Strasbourg. And you remember the first Labour government, 21st century, brought the Human Rights Act home so that you didn't have to take permission to Strasbourg or take cases to Strasbourg all the time. We had the Human Rights Act. This disjuncture between statutory regulation of the right to liberty and the jurisdiction of Article 5 of the Convention on Human Rights, you may find that you have to go for what used to be the right to liberty here under the common law. You have to go to Strasbourg and Article 5 now because you're constrained by statute. You don't have an effective remedy in the domestic jurisdiction. And modern slavery, there are innovations not yet enforced but not repealed either, which could further qualify the operation in respect to the public order disqualification if they're brought into force. It's a choice, having repealed 90% of the Illegal Migration Act, to retain these provisions even if they're not yet commenced. And it can to extend the public order disqualification where you've been sentenced to a period of imprisonment of any length unless there are compelling circumstances, and also to add categories to the grounds on which a person may be judged to be a threat to public order in relation to deportation related criteria, as you'll see at the 2 bullet points at the bottom of the slide, and say no stone left unturned. So that's legislation from the previous government that's been left there behind glass in case of emergency, and they need to show they're making efforts to do something without having to pass a new bill. They can simply commence this provision and crack down further on modern slavery protection. That's clearly a choice again to retain that. What's quite interesting is the shift, though, particularly in the emphasis from the previous government with the Safety of Rwanda Act, was looking at third country removal as a way of regulating its processing of asylum claims. This government's focus is on returns to home states, and the shift in policy is to look at home state returns. And in that context, the question of how the government approaches inadmissibility claims, where a claim is judged to be inadmissible, comes to bear. And the question, because of course, if your claim is inadmissible, you don't have a right of appeal, and you can proceed straight to removal. So the shift in emphasis has always been inadmissibility. Well, there has been recently inadmissibility jurisdiction in relation to judging asylum claims inadmissible to the home state as well as to third country potential. But you can see here in the retention of provisions which relate to home state, if I call that the idea that your claim you can be returned to your home state with your claim being judged inadmissible. That legislation has been retained and has the not only that which was first introduced by the 2002 Nationality and Borders Act, but the amendments which are yet to be brought into force but in the Illegal Migration Act. They're all there and available to the government. So if you think about the policy, not just in terms of the bill, but in terms of the executive action and the policies surrounding it that are likely to be used to maintain or emphasize and increase returns to home states under readmission agreements, this is the sort of tool for the processing or the non-processing of asylum claims, which is going to be used. And so what you have here, if the IMA provisions are brought into force, having not been repealed by the current bill, is that the Secretary of State must declare an asylum claim or a human rights claim, that's the innovation, made by a person listed in one of the list of states in section 80AA, must declare it inadmissible, and therefore it can't be considered under the immigration rules, which of course contain the provisions for the resolution of an asylum claim for protection for refugee status. And so again, this is looking at if the IMA provisions are brought into force, you don't have a right of appeal unless there are exceptional circumstances to take you out of being admissible, as a result of which the Secretary of State considers the claim ought to be considered, something of a judicial review playground there. Exceptional circumstances can include where a state has derogated from human rights under Article 15, a bit like after 9/11, the UK derogated on the basis that it was a public emergency threatening the life of the nation. So that's a very unlikely event, or where provisions are taken, funnily enough, under an EU provision, which is incorporated into UK law, notwithstanding Brexit, in relation to the EU regulating its own member states for infraction of fundamental rights as they're protected in the EU legal order. So the sort of countries you're thinking about there are Poland and Hungary, particularly Hungary, which is sort of poster child for non-compliance with EU human rights provisions. And so the states of home state inadmissibility is quite an interesting list. EU member states, the idea that, but bear in mind the human rights claim is not just defined in relation to Article 3, but also into Article 8. So it might become something of a blow to EU citizens to find if this provision is commenced that they have fewer Article 8 rights in relation to human rights claims than people from outside the EU. There might be a point there that the government might wish to reflect on as it seeks to rebuild relationships with EU member states, just a thought. EEA states in Switzerland, of course, so the EEA is Norway, Iceland, and Liechtenstein. And then even on Section 80AA, it was originally enacted Albania, picked on entirely for reasons due to the number of people coming from Albania and claiming protection. And that was embedded in the statute. And then just at the dying days of the last government, they a statutory instrument, Georgia and India were added to this list, which is still yet to come into force, but they were sort of added to the list. And they can be, by regulation, states can be removed or subtracted. So you can see what's on the mind of the Home Office, can't you? So Georgia, a country whose northern provinces are occupied by Russia, is obviously a case where there might be an inadmissible human rights claim. So it has it doesn't immediately spring to mind as an obvious candidate, but somebody thought so. So there are that's how that will work. And even if it and this is if the IMA provisions are brought in, but if they're not brought in, the government has still retained the ability, even without including human rights claims, to declare an asylum claim from a national of a member state. This means an EU member state inadmissible. So not just human rights. So they've already got this. They've got the other stuff if they bring it in under the IMA. But in any event, currently enforced, they have these provisions that an asylum claim from an EU state can't be considered under the rules except in exceptional circumstances. And so the interesting thing about that is, of course, you might think, well, how would there be an asylum claim from an EU member state? But it's not so far-fetched in the context of political changes in Hungary, in Slovakia, some of you have been tracking those sorts of things, potentially in Romania, the elections hadn't been nullified. We might be getting into the sort of territory where we once again start to think about protection claims, certainly from Hungary, if there was the first country that might be coming up on the inside track for that sort of tension. Don't mistake, other than this government's emphasis also is on home state removal to the home state. They haven't found any third countries really who'd be prepared to take UK asylum seekers, either this government or the previous one, of processing. But third country inadmissibility rules have been retained in force. And so if the weather changes, then these tools remain available. They haven't been repealed. And a lot of the current statutory iteration of third country admissibility that came in through introduced by the 2002 Nationality and Borders Act into the 2002 Act was innovated in the context of a renewed flexibility as a result of Brexit, where the UK was no longer bound by the Asylum Procedures Directive in terms of inadmissible claims and removal to countries. So that's there in the background. If things go sour and the government changes its policy, they haven't repealed those measures either. They've kept in force, of course, as I said, the cap on the numbers of entrants using safe and legal routes. They've kept in force some credibility amendments to Section 8 of the 2004 Act, and they have added to their suite of detention. You might have thought that with all these immigration acts that there was no detention power left uncovered left in various. They found one apparently, and so the clause 41 deals with this scenario which they refer to as clarifying, but which seems to have always speaking effect and maybe unlawful. It's something to look into, but it's There was some little bit of detention power that seemed to remain unaddressed, which may be an anxiety they have that they may have unlawfully detained people, and clause 41 seeks to address that scenario, almost impossible to conceive of scenario. But and so you can see that. So look at it all together. That's the suite of legislation that we're going to be confronted with. Watch out around the conferences and for a series of accompanying policies published as to how they're going to give effect to their new powers once this bill becomes law in the summer. And then good luck in the casework in challenging all of those things. And
very much, Adrian. That's truly depressing. I'd like to turn now to Audrey, Cherryl, Mogan. So many of you are immigration practitioners in this room, but Audrey is a criminal practitioner and just hot from the Manchester 10 case. And we would like to ask you to talk us through, from a criminal practitioner's point of view, the new provision.
I just wanted to kind of highlight a couple of things about the new criminal offences, because what better way to celebrate a new Labour government than add in some more offences for being a migrant. So supplying articles for use, here's what they are. Let me start with supplying and handling articles. One of the key things about this, and again, and I know there are people online as well, that I'm going to talk to you from a kind of a criminal perspective and what makes this truly horrifying. But again, as immigration practitioners, you'll understand that criminalizing immigration at all is incredibly problematic. But it's stuff like this. So we've got here this idea of supplying or handling. I've just put the handling legislation up there. But effectively, the supplying and handling are similar in the way that they've been written. But it's this idea of receives or arranges to receive a relevant article, removes or disposes of a relevant article, assists another person. And it's this that really worries me, the P knows or suspects that the relevant article is being used by P or another person. In criminal practice, it's very rare for suspicion to be an element. I mean, kind of rightly so, right? Because if you're gonna come at somebody with all the force of the criminal law, suspicion seems like quite a low threshold. It's usually intention or at least, recklessness. Suspicion is used mostly in fraud related offenses, not even the big fraud related offenses. It's kind of like things like possessing, disguising kind of handling things that you might have thought or suspected might have been criminal property. So the issue here is what you're getting with the asylum seekers, because whilst obviously it applies to a number of different people in the area of kind of the Immigration Act, I'm going to go to the lowest common denominator, which applies to Section 24D1, which is effectively anyone arriving in the country, which is basically any asylum seeker coming into the country. And so if you're you have a relevant article and you suspect that it might be used in connection with someone arriving to this country, you can be found guilty of a criminal offense in this country. That is so problematic. And it's just the fact that the only other areas that I can really look at in crime is quite serious fraud related activity, should make you realize that that's whatever this government says, that's where they're equating people, do-gooders, who are going to help asylum seekers. It's fraudulent activity. This is not them making the world a better place. Suspicion is a very, very low threshold. And it stresses me out a little bit to think about it. There is a reasonable excuse defense. it isn't what I originally thought, which was a reverse burden. It's not. It's like the MK Gega trafficking reasonable excuse. So it's, you just have to raise enough evidence. Sorry, that was in a trafficking context. You have to raise enough evidence to say that you had a reasonable excuse, and then the prosecution have to disprove it. But still, this is an offense that could give you 14 years in prison. I don't want to get super personal about this, but I'm a Sri Lankan Tamil. I was born in 1982 in Sri Lanka, right during the pogroms, during the riots, before what then ended up being a civil war / genocide. And the idea that people could face 14 years in prison for things that I know happened with my family. I know that legislation has gotten worse and worse and worse, but you know, the people that gave us money, the people that gave us phones, the people that organized our travel, that helped us, you know, this is the people that you're gonna go and stay with. This is what they could be facing, and extraterritorial jurisdiction. That is, that means anywhere and everywhere they can face these charges. So I get that a lot of this stuff has already been in there, and it's been more and more problematic over time. But it is, at least as a criminal practitioner who doesn't deal with it on a daily basis, kind of looking at it, it feels, wow, this isn't, I mean, Labour government can say whatever it wants. This isn't, it doesn't sound to me like this is doing something positive, or at least, whilst obviously repealing the Rwanda Act is huge, adding this kind of stuff in just feels incredibly, and you're criminalizing not just asylum seekers, because again, it applies to, and I'm using the lowest common denominator because it's important, for the Section 24 D1 Immigration Act people arriving in this country, who most of the time, and as Sonali has told us, are, you know, that's who they are. They're not entering, it's the arrival, and they're asylum seekers. So there are relevant articles. They've excluded this kind of stuff, food and drink. Most of it, oh, good, food, drink, medicine. They're not going to criminalize you for giving somebody food, drink, or medicine, or clothing or bedding. They've made it clear, though, if it's any kind of vessel designed to use, so any dinghies or any of that kind of stuff, then you still will be liable to 14 years in prison. But it's an incredibly wide definition. Whilst I was preparing for this, I looked at some articles and stuff that people have done, and our colleague Colin Yeo did a great blog on this, and made a joke about one of his articles, or free movement articles, not being an article. And actually, I don't think that's right, because I do a lot of protest work and I do a lot of terrorism work. And in the criminal courts, what you read, what you're looking at, can be used as articles to suggest that you are enabling something. So in fact, you know, watch out what you're reading, because who knows what you're going to be facing 14 years in prison. But it's so wide that, you know, it's that problematic. But anyways, other offenses: collecting information for use in immigration crime. Again, you can read what it is here. Some of the things that really worry me: by means of the internet, document a record. Again, in criminal proceedings, it's just idea of, I mean, it is obviously thought crime stuff that we're looking at here. How this is going to be actually enacted in real life in the criminal courts is so worrying, because it isn't clear. I can tell you again from things like joint enterprise stuff, gang related stuff, conspiracy stuff that we deal with, when they want to use nothing, which is i.e. a young boy having done, you know, put something on the internet that's clearly what all the celebrities use to copy it, they will use that to say that you're a part of something. So this kind of provisions in this act about by means of the internet or document, you might think that it's not that problematic, but in the criminal courts, it is being used more and more over and over again. Young people, social media, and it will be used as long as they have the will to use it. And you might think that just because the criminal courts are incredibly stressed and overwhelmed and there's too many people in prison, no, they will come for you because they're coming for everybody that they want to come for. And they're clearly putting this act into force and putting these provisions into force because they want to make this stuff illegal. And another thing, section 4, for the purposes of this section, information may be useful for a particular purpose, whether or not it may also be useful to members of the public at large for any purpose. I mean, yeah. I don't have to tell you, right? That's you can literally be criminalized or anything is kind of what, if you have a sympathy for asylum seekers, it feels like you're going to, and there are, let me just, if you're an NGO or a lawyer, get out of this. But other than that, yes. So there are, obviously you can collect this. This isn't going to affect NGOs and legal organizations who don't charge for their fees, who collect this information. But you literally can't do good anymore. That's it. You can't do something out of the goodness of your heart because guess what? You could face prison. Again, reasonable excuse. So this is one thing, and this is, I think, is interesting as well. It's a defense if you're charged with a defense under this section to show that their action or possession was for the purposes of a journey to be made only by them. These are lawyers who are drafting this. They could have said of a journey to be made by them, but they said only by them. How many times have you seen one rando just on a dinghy coming? It's not, right? It is going to be a group of people and it's never going to apply to that person because it's never only by them. And then again, a reasonable excuse. This is what I was saying about NGOs, journalists, academic researchers. You'll get the slides. There's the way out of it, but it is incredibly problematic thought crimes. And for this offense, it's 5 years. And again, like I said, it's not a reverse burden, it's an evidential burden. And this, in this section, record includes photographic or electronic record. I mean, the amount of times people take pictures of things. Yeah, all of that can be used as evidence. I've already said extraterritorial jurisdiction. I mean, how that's really going to work is going to be interesting. But that's the gauntlet they've put down. The other offense I want to talk about is endangering another during sea crossing. One of the things that really hit me, and I'll tell you a little bit very briefly about a case I've just done, and how it kind of relates to this, is the idea of the people that are basically forced to hold the tillers, right? The people that don't have any money, or people aren't, the traffickers aren't idiots, right? It's, they throw a bunch of people in, the most vulnerable person ends up being the person holding onto the tiller, using the rudder. And now, if that could endanger in those tiny dinghies across that sea, if that could have an impact on someone's life, or also not just physical, but it's also psychological injury, which I think is interesting. On one side, I can see the perhaps positive impetus for that, if this was actually going to address the problem of people trafficking, and someone didn't have necessarily physical injury, but through the you know, horrific experience of being trafficked from country to country, had severe psychological injury, which obviously happens in most cases, then there's a way to deal with that, but there is already a way to deal with that. And so I don't see how this is adding anything other than criminalizing someone who's been forced in a situation into a completely inequipped boat to then have to make their way across, having nothing to do with the original. Well, because they could have charged them with Section 25 facilitating if they don't have the evidence to show that they were actually facilitating. But now look, well, you're putting somebody's life at danger, so now you can be done for this. It is quite gross, is my conclusion of all of that. I just wanted to say a little bit about this from a criminal practitioner's perspective. This is obviously the Section 24 D1 Immigration Act stuff. It's from the previous legislation, but I thought it might be helpful to you guys to hear, whether you're criminal practitioners or immigration practitioners or whatever, about how it's functioning in practice in the criminal courts. Because I recently had quite a ridiculous experience of this, where I was instructed in a case, and it was very clear. This was, I mean, it's a Sudanese national, Darfuri, so all clear, going to be granted asylum. Hand on the tiller, I mean, less than 20 minutes. They're, you know, dropping the Section 25 charge. So I'm in court saying, sorry, we're going to run an abusive process argument because you shouldn't be charging them with the Section 24. You're effectively, literally, you've said Section 25 doesn't work because you don't have enough evidence to suggest that they facilitated the arrival. You're literally criminalizing the act of being an asylum seeker. And this is a person from a country and from a community that you know is going to be granted asylum. The response from the court is very much, sorry, what? You're not just gonna plead guilty right now? No, I'm not. What should have been in normal other cases, I'm running an abusive process argument. That's it, that's what we're doing. This person's pleading not guilty, fine, in and out. No, is nonstop questioning from the judge. I don't understand what is going on. What's your argument? Well, here's the case law. I was ready, thankfully, because of Sonali and Jen, I was ready. And still, no, I want your argument tomorrow. No, I'm not gonna give you my argument tomorrow. Okay, fine, in 7 days. An abusive process argument, let me just make it clear to people who don't do crime regularly, that isn't something you would do ever in 7 days. You do it in a few months' time. You mostly do it on the first day of trial, which usually happens now in a couple of years. So the idea, this was pushing and pushing to say, why aren't you just doing what everybody else is doing? Which is, if you're an asylum, if you've got an asylum seeker, they came in, they're being charged, plead guilty. And that, it was scary. So I said, no, we're gonna do it. My defendant was in custody, obviously. And we got time, but we were, you know, gonna do everything quickly, put in those arguments, came back. And again, for people that don't know about crime that much, if you plead guilty at the magistrate's court, so it used to be you get 33% if you plead guilty at the first opportunity, and they considered the first opportunity was in the Crown Court, because, I mean, nobody gets good advice in the magistrate's court. But in about 2017, they changed that to it had to be in the magistrate's court. And to argue with the criminal judge that you should get anything close to 33% if you've pleaded at any time after that is effectively just a non-starter. You get 33% at the magistrate's court, 25% at your first appearance, okay? So it goes down that significantly. Those are days and months of people's lives. Effectively, I was told, look, if you plead guilty, we've got your skeleton argument. If you plead guilty, I'll reenact. This is like 5 months into the case. I'll reenact the 33%. He'll get out today. Now, I don't even really, I mean, there's no world in which I'm going to say to my defendant, don't plead guilty. You will get out today. The criminal courts take forever. This is a legal argument. It's complicated. It is a really, really weird world where immigration meets crime. And it is not fair. But yeah, other than that, that's all I have to say.
Thank you very much. It shows it's really interesting. It's really important for us as a chambers because we're multidisciplinary to share our experience and practice and sort of inform how we, how we go forwards. And to that end, Jen and I worked on Jen Twite, a public law barrister with a criminal focus, and Jen and I worked on one of the full boat prosecution cases, Mohammed, which Jen can talk about now.
Hi. So I'm the last speaker, and what I want to talk about is what it doesn't do. I know Adrian talked a little bit about what this bill doesn't do. I suppose in some ways I was trying to be more optimistic. Well, I know we've had a really depressing presentation, because I know that some people, and I hope that some people, are working on amendments to this bill, and I was hoping that maybe we could try and use it as a platform to make some changes to things it doesn't yet make changes to, and maybe that is me being too optimistic, but we've got to do something, otherwise it just gets more and more depressing. So as you just heard a little bit from Audrey, I'm going to talk a little bit more about the Nationality and Borders Act, which this bill is silent on, and the harm that's been done and the criminalisation of asylum seekers that started happening by NABA. The reason I say I want to talk about this is perhaps to look at what amendments could be made, what might be realistic in terms of those amendments. And I thought tonight would be a good forum, especially since we've got so many people here. And hopefully after I stop speaking, you guys can ask questions and have some ideas about it to discuss, among other things, what changes could be made through this platform to do that. So I've got a couple of things that I wanted to kick off with about what amendments could be made. But before that, I was just going to give a very quick whistle-stop tour about where we're at in the criminalisation of asylum seekers. I'm going to go through this quite quickly because it's familiar to a lot of people, but I thought it was a good place to start. As most of you know, in June 2022, the changes came into force from NABA, and since then at least 455 people have been prosecuted for coming into this country for mere arrival, all of whom have got, as far as I'm aware, prison sentences, and certainly the sentencing guidelines suggest that they would get at least 12 months imprisonment, which, as Sonali pointed out, immediately triggers automatic deportation. And so a lot of those people are now not only got prison sentences, a criminal record that will never leave them, but they're also liable to deportation. And in order to be guilty of that, they simply have to arrive in this country without a visa, which, of course, if you come from one of the countries that most of them come from, Eritrea, Sudan, Afghanistan, it's not possible to get a visa. It is true that less than 1% of those people who come on small boats do get prosecuted, but as I say, that's still, we're talking already in the hundreds, and without further amendment or further change, that obviously is simply going to go up. So I wanted to start with Article 31 of the Refugee Convention, which I've put on this slide, because of course that is what we are supposed to be complying with as a country, and what is supposed to stop us criminalising people from coming and claiming, what's supposed to stop us, prosecuting people simply for the act of claiming asylum. And so understanding what it says and how we can use it is obviously the starting point. What I've underlined, is my underlining in this, is the words coming directly, because that's really where we have the biggest issues in terms of understanding and where the government really uses this as a way of trying to prevent us using Article 31 to protect people for claiming asylum, because the argument often used is that if you've come from France, which you must have done essentially if you're coming from a small boat, you haven't come directly from Sudan, Eritrea, or the like. There are UN HCR guidelines that have been published recently, and they do particularly deal with the point of coming directly, and they are helpful to read. I haven't set them out on this slide. For those of you who haven't read them, they do essentially just summarise the case law that already talks about this, but of course says that coming directly should be interpreted broadly. It's not necessarily to be interpreted in a literal manner. Mere transit cannot be considered to interrupt coming directly. And that each case has to be assessed on its own facts and circumstances, taking into account the realities of flight. So the whole point is, and again, this is backed up by the case law, the UK, there's obviously international case law as well, but I've set out the main UK case law on this slide that deals in particular with coming directly. That it's not a question of whether or not you've literally got on an aeroplane from your country and come directly to the United Kingdom. It's not a literal interpretation. The whole point is it's supposed to protect people who have come here in a much broader sense of coming directly, i.e. they haven't gone and claimed asylum in Germany and lived there for 5 years and then changed their mind and come into the United Kingdom. People do come in complicated manners, and they do often have to stay in other countries, either to get money to continue, or they end up staying in other countries like Libya, where they get trafficked, as I'm sure many of you know. And so actually, and I think actually the main important point to take away from some of these cases is the fact that they all talk about the element of choice that's open to refugees as to where they claim asylum. And so when we hear arguments, which we have done in some of the cases that we've tried to run and are running in the past, that, you know, they've come from France, why haven't they claimed asylum in France or Italy? It is an important principle that when you are claiming asylum, there is some choice about where you claim asylum, and you don't have to claim asylum in France. And therefore, otherwise, of course, if that were true, every single person on a small boat would not be entitled to protection, and then we would be in even more difficulty than we already are. So that's what Article 31 deals with. So I want to move on to NABA, the Nationality and Borders Act, and all the different things it does. It does an awful lot of bad things. I want to concentrate on the particular ones that I think are right for looking at tonight. The first is section 37 of NABA. And this is actually subsection 5 of section 37. Section 37 is broader. And as many of you will no doubt be aware, after the case of Ademi, the government introduced a defence under section 31 of the Immigration and Asylum Act 1999 to add a statutory defence to some offences, so that if you are charged, for example, with possessing a false identity card that you've used to come into the United Kingdom on, for example, a flight, you've got a false passport to get here in order to claim asylum, you can run a defence in front of a jury to say that you shouldn't be prosecuted because you only committed that offence in order to come here to claim asylum. And the point of section 31 was to give effect to Article 31 in law. And it's important to remember two things, I think, when we're thinking about this, about how that helps. Firstly, of course, it means that if you get charged with offence, say an identity card, a passport, because you've used it to come here to claim asylum, you can run that defence in front of a jury and you can be acquitted. But actually, in reality, what happens is you don't get charged with it so often, because when the CPS look at whether or not to charge with that, they go, oh, he's got a defence, and you don't pass the full code test, you don't pass the evidential threshold. And so we do see some, and there have been cases in the court where people pleaded guilty because they were badly advised about whether or not they had a defence, but you don't see as many cases for this because they don't get charged in the first place. And so, of course, having that defence on the statute books has a sort of dual protective effect, I would argue. The first then bad thing that NABA does is amends it to say the words I've underlined, which used to say that you could only, a refugee was only to be taken to come into the United Kingdom directly unless they could show that they could not reasonably expected to have been given protection under the Refugee Convention instead of expected to have sought protection under the Refugee Convention. So sorry, I've underlined the whole sentence. It's actually obviously in the word sought and given that been given have been changed, but you need to read it in the context. And that's quite important because there is a big difference between whether or not someone can reasonably be expected to have sought protection and be given protection. Because again, talking about the France example, which is the one that's often the one we have to deal with, because if you've come on a boat, it's very difficult to argue you haven't been to France. If they haven't sought asylum in France, if they just walked through France and it's taken them a week, of course they can't have reasonably be expected to be given asylum because they didn't claim it, right? So you kind of got around that quite quickly. The moment you change it to a better sought protection, the question is, well, why didn't you claim asylum in France, right? So those words actually make a massive difference to that protection. And those words, therefore, totally undermine all the case law I've just talked about and what the UNCRC say about Article 31, right? Because it gets rid of that idea of choice. Now, I actually don't know, I'd be very interested in anyone's had any experience of how that's worked in practice in terms of prosecuting offences in the criminal courts. But theoretically, that is a massive difference that could be really problematic. And so again, one of the things we worry about in NABA is that. The second, obviously, big issue that Audrey's already touched on is this new offence. And there were a number of new offences created by Section 40 of NABA, but in particular the one of illegal arrival. Used to be illegal entry, and now it's illegal arrival, which means that everybody coming on a small boat is committing an offence. NABA also amended Section 25, making it easier to commit the offence of unlawful facilitation, and also upped the maximum penalty for all of them, meaning Section 25 in particular is now life imprisonment. Vicky Taylor, who's here? Sorry, wrote an amazing report, which I've quoted also. If anyone is interested in further details about what's been happening in terms of the criminalisation of small boats, I really would recommend reading that, and it details in quite a lot of detail who's been prosecuted and the numbers involved and what's been happening on that. But in particular, there is no defence. The Section 24, that was set out in Parliament quite deliberately, that anyone, even those who are claiming asylum, would be covered by this offence. But it was said from the outset, that doesn't mean they're going to prosecute everyone. Decisions on prosecution remain a matter for the Crown Prosecution Service, who will, they say, consider the public interest test. Well, as Sonali said, she led me on a case of Mohammed at Canterbury Crown Court, where we argued about what defences there could be. And again, we were told no defences. All asylum seekers are guilty of this, but don't worry. It won't be appropriate to impose penalties on refugees if to do so would breach the United Kingdom's obligations under Article 31. And that will all be okay because the CPS will apply their public interest test. Well, what do you do if they don't apply their public interest test? Theoretically, it's either an abuse of process or judicial review. This was dealt with, as I put on the slide, in Mohammed. Also, I put on the slide the case of AAD because that's really useful in setting out how abuse of process works, theoretically, in criminal cases where the prosecution don't comply with their public interest test. Audrey's already spoken to you about her attempts to run an abuse of process argument and how that has worked. I don't know of a single abuse of process argument that has been run, certainly not successfully so far, and yet lots of people who have now got refugee status have been prosecuted and have spent time in prison. So challenging decisions to prosecute hasn't been particularly effective thus far. So finally, what could we do about it? So ideally, if I had a magic wand, I'd repeal Section 40 of the Nationality and Borders Act. It does more than I've spoken about tonight. I recognise it might not be politically possible, possibly just repealing the worst bit, which I think is section 40, subsection 2D1, which is the offence of illegal arrival. That would still leave an offence of illegal entry, which essentially criminalises people who enter surreptitiously, but would allow people who arrive on small boats and immediately claim asylum to not necessarily be criminalised. Maybe that's also too ambitious. The other thing that I think is worth considering is adding defences to section 31 of the Immigration Act. As I said previously, there is this defence. It is only, I've set it out there, it is only applicable to an exhaustive list of offences. So if you come in with a false passport, you can run this as a defence. You're less likely to get prosecuted. If you do get prosecuted, you can run your defence in front of a jury. If you come in just illegally, in a sense, irregularly, as in the sense that you haven't got a visa, you can't run it as a defence. Bizarrely, there are a couple of cases now where people have been charged, and it'll be interesting what happens, people have been charged with both false passports, for which they do have a defence, and illegal arrival, for which they don't. So if the jury can acquit them of the false passport, because the jury can, where does that leave the section 24? Does that make that an abusive process? When do you run the abusive process argument? I'm opening this up to the floor because I've been speaking to people like that. Do you run it after the jury's acquitted your client? Because that's not normally the way it works. So I think it's really problematic that we have this exhaustive list of offences, and it makes no sense which ones they apply to. Like, why is having a false passport? Fraud is one of them. You can commit fraud and argue section 31, but you can't dare to come here without a visa and have a defence. So like, it makes absolutely no sense. We don't actually need this new bill to fix it, because actually by section 3110, the Secretary of State may by order amend it. But equally, obviously, it would be time. So she actually could do it she could do it tomorrow. If she wanted to. Maybe she doesn't want to. But this feels to me also a little bit more like a compromise position, which is why I thought I'd raise it, because it's not repealing it. It's not saying, okay, we're letting these small boat people come, who I can imagine that might not go down well at the moment politically, but it is saying maybe we should have a better way of them running these defences. And so that I thought was an interesting answer. But any other answers or any other ideas, be delighted to hear. Thank you.
Yeah, and this is what happens when you have criminal practitioners and immigration practitioners and public practitioners all in the same room all at the same time. Fantastic. And it does give a lot of food for thought and ideas. So we have got a little bit of time for questions. Don't know if anyone's got any questions or comments. Yes, go.
Thank you. I've got a question for Audrey, actually. I am I'm a policy and campaigns officer at Liberty. So to preface this, I'm not a lawyer. I'm definitely not a criminal lawyer. So I have to give me some background in your response. But we're looking at this bill from the perspective of terrorism and kind of how it's mirroring some of the terrorism offenses that already exist and taking some of the definitions and language that are used for defining things like possession. So I was really interested in what you said about suspicion being a really, really low threshold.
Yeah.
And I wondered whether you can talk about how the suspicion threshold compares to thresholds in terrorism. As far as I'm aware, they use intent or intention.
That's a big question. Most offenses, even in terrorism, is intent, but there are, again, where you have the will to want to convict people, there are suspicion offenses within the terrorism area. But it is what I said, which is suspicion is I used fraud, and it isn't like the main fraud offenses. It is what we're talking about is like you're getting something from someone else, and the idea is you suspect, and that's under the Proceeds of Crime Act, which a lot of people themselves have said, and there's been a lot of work done about how unfair it is anyway, because suspicion is rare, right? We can chat later just more about the kind of overlap with that, but basically it is incredibly rare to have suspicion. In fact, it's always a good speech point. Suspicion isn't enough, right? It's intention or that you know something's gonna happen and you go out to take that risk with intention or recklessness. And that is really what really struck me. Because it's effectively saying you could suspect somebody's gonna use it for this. They are lowering the threshold so that they can bring more people in, but.
I was just thinking, there's also the, you've got the Supreme Court case of Jogi, which is obviously about something different, it's about joint enterprise, but the whole point of that was foresight, right? Because they used to use foresight for joint enterprise, and I said, oh, that's not, you foresee something, that's not enough, you have to intend something to happen. You might have conditional intent, and so that's a whole like case discussing all the different levels of, it might be worth looking at it, because obviously they talk about the difference between conditional intent and foresight, and why foresight isn't enough, why it's not fair to convict people on basis of that, and why you need intent. Or intentional recklessness is like, I mean, obviously, because obviously the point of intentional recklessness is you know there's a risk, you have to know there's a risk and you go on to take it. What does suspicion mean?
But
They
they
suspect all
definitely,
sorts of things when in the right mood.
I mean, I don't know if it's luckily for Jogi, but it was murder, right? Unfortunately, in fraud, you can suspect things, but it's this real worry that why are they putting these offenses within that level of low threshold? Is it so, I mean, it's actually, especially with the extra territorial effect, are you really, what, you gonna pull someone in from what? Libya, you gonna pull someone in from Sudan, like where, or France, I'm guessing, and to say you must have suspected, and it does bring up a lot of issues. It's a lot different from what actually happens in the cases, in the offenses where it's like, say section 329 of the Proceeds of Crime Act, right? It's like, oh, you suspected, oh, this person just pulled a whole bunch of stuff out of the back of a truck, yeah, and just passed it to you. You might have thought or suspected, you might have known or suspected. That's quite a different situation than this. Yeah, I don't know, that doesn't answer your question, but we can chat more about it.
So that's really helpful.
Also, I don't have all of the terrorism legislation in my head.
I don't
You know
either.
that we are happy to get you under terrorism legislation if they can.
Well, I imagine that the extraterritorial provision was because the commission of offence would have started
Started.
off the channel or in the middle of the channel or in France, but it carried on here and they're only going to prosecute you if you're here, but they wanted to prosecute you for something that started outside the jurisdiction.
Yeah, but this was my point, like, they're not gonna go after you if you are still in France, really, right? And so, I mean, they will for lots of offenses, but I mean, the criminal courts will still go after you for a lot of things. I think it's quite, I don't think that, so it's just an interesting kind of, like, why have they done that? And is it more of a deterrent than anything else? Because to put a lot of money, obviously, when it comes to things like actual traffickers, that makes sense. But sorry, somebody Googled the weather for you? Is that what we're gonna put our criminal justice system resources into? That feels weird, but anyway. Who knows?
Another question at the back, and I've got a couple online. Yeah, go ahead.
Hi, I'm Travis, University of Bristol. I was just wondering about this abusive process possibility. And as I understand it from you, you weren't able to run the abusive process because your client pleaded guilty. And then I was wondering, is there an argument that you think could succeed? And then what could we do to help try and secure bail for people that are not facing the pressure of being incarcerated while you have the time to prepare?
Jen and I nonstop on the phone, her being like, you need to get in bail. I'm like, it's an abusive process. It's 100% an abusive process, but I don't think you'd necessarily win in Canterbury Crown Court. With that argument, you'd have to then say to your client, you're in custody. I'm probably gonna lose this legal argument here. Stay in custody whilst I then take it to the Court of Appeal. I might win there. Let's try the Supreme Court. It's just, but it is the right it's crazy. I mean, I could stop talking because actually the two people who argued it are here, but from the actual lower court perspective, it became impossible to say to someone, listen to my very right legal argument when you're being told otherwise, plead guilty and you could be out today, but.
I think there's a very strong argument that's an abusive process, but I think the difficulty really comes down to words coming directly again. I think the CPS almost concede that if Article 31 applied to any one defendant, that they shouldn't prosecute them. What they tend to say when they are forced to think about it, which they often haven't thought about until you make them think about it, which in itself is interesting, is that your client hasn't come directly because they spent X time in France, right? So that's why I think so much this turns on what we mean by coming directly. Now, I would argue, as I just have, that actually it's a lot broader than that, and often they're wrong on that. And then it's going to come down, if we ever run an abusive process argument, or if anyone ever does, it all depends on the facts and circumstances of the case. I mean, I would argue actually that it goes further than that, that even if you haven't definitely come totally directly, that like you still might not be in the public interest to prosecute you, because the CPS's public interest test is actually wider than just whether or not we're complying with our international obligations. So yes, I think it's a great argument, but given no one's won it, it's difficult to say that. The other point then, as you say rightly, is no one gets bail. And I don't know why entirely, because most of the people, some of the people who get charged have got family in this country where they could go and stay with their family. They're all entitled to accommodation under Section 95. They can all go and stay in a hotel.
People who've already been
their lives to come to this country. They're really keen on staying. They're all going to get asylum. Right, this is the thing. They're all going to get asylum. And because they're all Sudanese or from a country where they're definitely going to get asylum, it's massively in their interest to cooperate with the British state. They're actually probably more likely to turn up than most of the people that are to do bail. But none of them have got bail, so I don't really, what can I say?
That's not how the criminal courts think.
So I want to add just one thing about the definition of Article 31, immunity from penalty, was amended in NABA. So they're saying there that you're not coming directly in statute if you could have reasonably be accepted to sought protection. So
then
that's how those two things marry up. But sorry, lots of questions. This is very exciting.
Actually, the question is about this the recent change of guidelines by Home Office about the character reference of those who are coming illegally, maybe after 10th of February and or before that. It has created a lot of anxiety among our young people. So, for example, a young person just called this morning. She came 7 years ago, but she's now entitled to apply for citizenship. But now she's saying that the law or the guideline says that she's not entitled. And also, same applies for our adult clients who are now receiving a lot of calls from them. What will happen? So, is there any chance for example, the application is rejected? Any chance for appeal?
So, I mean, so first of all, it is in policy, not in statute, as things stand. And you have to make an application, and there's a discretion within the policy. It says will normally, is that right? Be refused if you've entered illegally?
This one is more rigid. So it's just for the context of the room, there's a good character test on an application for naturalisation. The test is statutory, but it's not defined in statute, so there's a policy. And if you arrive without entry clearance or an ETAS, electronic travel authorization, having made a dangerous journey, then Sonali's right, you will normally be refused citizenship. But if you apply for it after the 10th, from the 10th of February, and a dangerous journey includes, but it's not limited to, arriving by a small boat. So it's not exhaustive, the definition of dangerous journey for the purposes of naturalisation. So the problem is that we'll normally bid. So of course it's not entirely rigid. So you could make a representation to say, you will normally do it, but not for me because of X, Y, Z reason. So that relies on you getting a lawyer who is skilled in nationality law and in refugee convention law to run that point for you. But if you're making an application for naturalisation, you don't know that, you're just doing it on your own, saving up to pay the enormous fee for naturalisation, then you probably won't know that and you'll probably fall foul of it. So it is kind of, in practical terms, it's going to catch people.
I mean, the policy itself is under challenge in a sort of, on a policy basis without an individual or possibly with an individual, not sure. But and it's obviously on the face of it in breach of the non-discrimination provisions within the Refugee Convention. If you're a refugee, you shouldn't be discriminated against in relation to other nationals, and certainly not by method of, it's also in breach arguably of Article 31. So there are challenges that can be made. There definitely is a challenge afoot, and there certainly needs to be individual cases that are brought with reference to Article 31 and non-discrimination, particularly for places, people who are refugees, they're not going anywhere and they can't be reasonable.
Exactly, and don't forget Article 34 of the Refugee Convention, which is supposed to facilitate naturalisation of people recognised as refugees. So obviously here we're talking about an evaluative judgment within a non-statutory definition. Should Article 34 apply? It's not prohibited by statute, neither is it expressly referred to. Piece of international law, effectively, in which the UK is bound. How does it guide the exercise of evaluation of good character in this context?
We've heard a lot about the UK's commitment to international law.
Yeah.
Just take your another question there. And
Thank
then
you.
I wanted to ask in relation to the offence of facilitating illegal entry. You mentioned a trafficking case and talked about the evidential burden, but the text of the statute kind of indicates that the person who is charged with the offence would know that the people entering would be asylum seekers. Obviously, in the circumstances where this would arise, it's not like they could be undertaking an asylum interview per se. So just on a practical level, what kind of evidence do you anticipate would need to be raised in order to reach the evidential threshold to try and run this kind of defence? Because on its face, it seems like it's trying to counter criticisms of pushbacks and the like in Europe by creating this defence and statutes, but in practical terms, is it actually possible to run it?
that is a very good question. I don't have the answer off the top of my head. It is definitely an evidential burden, but I'm just trying to.
Evidential burdens generally are quite low,
Yeah,
right? So
it's
you
to
go,
say,
as long as, like, I mean, in crime generally, like, you have evidential burdens in almost anything. Like, if, for example, if you run self-defense, you have to like raise it. You can't just. The point of an evidence, the different types of burdens in crime.
it is different from self-defense.
Yeah, but like you have to raise something. But like if you just said, I thought they were refugees, surely that's enough. Probably. Like you don't have to say very much. The point is the prosecution, the point of evidential burden is the prosecution doesn't have to go through and disprove every single defense you could possibly like come up with, because that would make a trial impossible.
Yeah.
The point is you have to say something so that the prosecution know that it's a defense, so then they go and have to disprove it, right?
Yeah,
So like I think it's quite a low threshold.
I mean,
which is
the
my answer.
comparator is section 45, modern
Yeah.
slavery, right? And it's true, you don't have to provide anything. You can say, this is what happened to me.
Yeah.
And then they have to disprove it. So that must be right. That must be the same thing. It's just, yeah. It's a big question.
Oh, and your question,
Yes, thank you very much. What do you think the rationale or implication is in retaining section 60 of the IMA, but repealing 61, which is the report on safe and legal routes? I don't understand why they would remove 61 and keep 60 if they aren't sort of in conjunction.
I mean, I mean, 60 is the requirement to report on safe and legal routes, to have the cap and consult unless there's an emergency. I think it's probably totemic to suggest that they have control, because in the previous government they said, oh, let's have the Ukraine scheme, and I genuinely don't think they had any idea that there'd be 250,000 people who would apply and be granted under it. Well, if they did, they didn't tell anyone that at the outset. So it possibly something to do with that, but why they've got rid of 61, I don't know. In those circumstances, but I do think they want to say, look, there is a safe and legal routes. That's a big thing for us, but we're not going to let it be unrestrained. There's a couple of quick questions online. Just does the ILPA Joint Committee on Immigration and Crime still exist? If it's, I'll ask Zoe that, or someone else can answer that later. Quick question: will individuals donating article of funds to charities such as Care for Calais or others be liable to prosecution? So we've got the exception,
The NGO
Right.
exception.
and that includes, that's not just confined to the clothes and food, but also to money. Is that right?
Yeah, and that would be more the collecting of the information, right? And they've got specific.
All right, well, she was specifically talking about articles and funds, so I think we're okay. with that one. And there's a question for Adrian. In section 29 IMA, what's the official definition of liable for deportation? Is it regarding offender status, or does it also include people, for example, who overstay? And in that way, does it widen the public order disqualification?
It's related to the definition of liable for deportation in the Immigration Act 1971. So it depends on whether Secretary of State deems your deportation to be conducive to the public good. So that's a judgment for the Secretary of State, and also if you're a family member of someone who, in respect of whom a deportation order has been made, or if you are, if there's a recommendation made in a criminal court for you to be deported following your conviction for an impressionable offence. So it dovetails together. So it's it's piggybacking on something to widen it to include deportation related things within the scope of the public order disqualification.
So thank you very much, everyone, for coming.